So Ian, I was just introducing our series on high risk instructions and excluding children being, maybe the highest risk. So let's turn to, first of all, do you want to introduce your thoughts on this whole topic of high risk instructions excluding children?
Sure. I'll just have a couple opening comments. I've been thinking a lot about this because, it's coincidentally, yesterday got a retainer for someone who's going to exclude a child literally yesterday. It's just one of these topics that, as a litigator, from a litigation perspective, of course, this is easy pickings if it's not really thoughtfully done by the solicitor who's drafting. Because of the inherent bias against this. And I just say that is a natural expectation of the judge going into any trial, that you better have a good reason why you're cutting your kid out. So I sort of have my own test in my mind, both when I'm trying to attack or defend it, or when I'm drafting. And that is that, and I've sort of thought this through carefully, a documented, clear rationale for doing it. And I want to parse those words out just briefly. Documented, obviously, we're going to talk about, and we're going to talk about some of the options there. That's an obvious piece because of the unique red flag that it is. The clear rationale is where a judge is going to be, and we'll talk about what that means, but a judge is going to be looking to. And why I say that in large part is because that's precisely what any good retrospective opinion is going to highlight on, is that was the rationale a clear rationale, and notwithstanding maybe even some mental frailty, but what was the rationale for the decision? And I think both of those words, the documented part and the clear rationale for doing it, we can parse out in our discussions today. But I try to keep that in mind throughout. And the last thing I'll say is that in terms of analysis, I want to make sure when I'm taking instructions like this, that I'm coming back to the topic in a casual and professional way throughout the discussion. So when it comes up or when it's broached, I'm not afraid to come back to it, and sometimes 2 to 3 times, depending on issues of capacity and level of capacity, or more importantly, depending on the rationale, because I have to tease that rationale out. So those are just sort of like an overview analysis that I always go through when I'm either attacking, defending, or drafting.
Thanks, Ian. So here we touched on, these are sort of the general assumptions that people have, judges and kids. So the first thing you made, your point was, we're going to start with the premise that all children are going to be treated the same way. That is a general assumption. Whether it exists in law or not, it is. The next assumption is basically that expectations will be met, so that they're, if mom was going to cut me out, I'd know about it. The lack of surprise, which often it is a surprise. And then we get to the sort of the legal. Well, first, before we get to the legal thing, it's this concept that kids have that, my parent would never really want to treat me differently than my siblings. So if I am treated differently, it's either because my parent didn't know what they were doing, they were incapable, or they were coerced to do so, right? And Ian, that of course is capacity and undue influence, right?
Sure. And I think, and your last point, of course, it's the lawyer's job to make it sure everything is equal, is a part of the assumption that gets imparted on us, which can't be forgotten. But I don't want to underestimate the importance of my experience of the importance of this concept of these general assumptions. It is as high as, from a practical standpoint, it is as high as a presumption of capacity. And we all understand substantively that presumption of capacity is the law. And I would go as far as to say these general assumptions are as high as, from a practical standpoint, when the analysis comes in, being looked upon by the court.
So And of course, I put assumptions in quotes. It isn't necessary. It isn't the job, I guess, of the lawyer's job to make sure everything is equal. Although that's what kids would expect. And did you try to talk them out of it? And did you, so there is kind of that assumption.
Well, that's
So,
right, and I think but that's the point. It is something that is foisted on us,
mhm,
and when we get this red flag, we can't run from it. We've got to take our clients' instructions, but we have to appreciate these core assumptions are going to be any litigator is going to come at you with.
right. And it's good to acknowledge them. I mean, when I came up with, I wasn't anticipating doing this slide, but it just came, because these are this is where courts start, and this is where people, even if they're not going to litigate, this is where disgruntled beneficiaries start from, and so I think it's important to sort of acknowledge that, because this is what we're going to be attacked on, in a sense. So, just some key information. Maybe I'll just address the first one, and you can address the next two. And the third one really is that we have another slide about that, because that's really the key thing that you've mentioned. But it's important, in my view, to make sure that we know about everybody who would be expected to be treated the same. So, obviously that's where we can get in trouble, where we didn't dig down, whether it's, children, we would probably know about children, but often it's stepchildren. Maybe they're expected to be treated the same, especially in a second marriage kind of situation. So digging down to see, okay, who's everybody out there that would have these assumptions, I guess, is the first thing.
Yeah, and from a practical standpoint, that means a careful family tree that's done accurately, and thinking about it. I mean, I've got sort of mantra in my head when I get into these things, and I, as I said earlier about what my documented clear rationale for doing it is in my head. But the second is that what is testamentary capacity? Well, a foundational element of testamentary capacity is know and understand the nature and effect of your dispositions, and on those who would properly enjoy your bounty. And those who properly enjoy your bounty is used broadly because the courts have expanded what that would mean, and stepchildren is an obvious one to some people. But if you haven't done a careful family tree, you might not have all the stepchildren. You might even miss stepchildren.
Right. Obviously, two is, okay, the client comes in and says, okay, and by the way, I'm not going to give my son anything. So all of a sudden we know, okay, who now is not being treated the same? And it may be more than one person. And then it brings us to that fundamental question, really the only question that really matters is why. And so maybe, Ian, just take us through your thoughts, both from a litigation point of view and as a solicitor, how we should deal with this question, and we can have a little dialogue on that, I guess. But why don't you lead off?
Sure. Well, this comes back to my big worry, and is that what is the rationale behind it? One word answers are often the first reactions. I'm estranged. I haven't talked to him or her for many years, or you get a kind of a cursory response. And I layer it down. Like once I've got the red flag flashing in the room, I start layering it down. And it's a sensitive topic. I mean, I've never had a case, well, not never, but rarely have a case when I'm taking instructions when someone's being excluded, where the parent isn't a little bit embarrassed. And so I'm not going in like a bull in a china shop saying, oh, great, tell me all your family stories. I just start to drill down a little bit. Okay, well, the why. All right, estrangement, good. And then maybe I'll move on to something else and come back to, okay, Sonia, you talked about the estrangement. Now, can we just talk a little bit about, let's drill down on that a little bit. I don't find clients are resistant to tell me about it, but if I get sort of these curt sort of answers that, oh, he never loved me, or he was always a pain in the neck when he was a teenager or something, so, comments that may or may not have a good solid rationale behind them, then I haven't satisfied the test that the court is going to expect. And that is that you need a clear rationale. And a rationale could be one word, but that's not a clear rationale.
And so I've highlighted some, some red flags. This is especially, there are different stages of life where this is more or less risky. Obviously, younger parents who are, in their 60s or whatever, and where there's no capacity issue whatsoever, um, different than, a more elderly person, a parent. And I've highlighted red flags. This is actually a red flag for us. The classic, why are you cutting them out while they're stealing from me? So there's, and that's a red flag because often that's not actually true, right? What's your experience with that kind of answer, Ian?
Yeah, and that's really important because it's that comes back to the clear rationale. And first of all, the stealing is something that is almost always inaccurate at some level. Um, they feel that it's being stolen from them as opposed to that it's stealing. And then they find out, well, it was a joint account, and I never said he could go into it. Now he is, you know. But there's an emotional attachment to stealing. But stealing is an overstatement that I always want to say, okay, wait a minute, what do you exactly mean? Because that could demonstrate some mental frailty or some delusions. It could demonstrate all sorts of things that if I just take that at face value, then I haven't, broken down the clear rationale.
I always ask, when somebody, and I've had this a number of times where an elderly parent says, "Oh, cutting them out because they're stealing from me." I say, "Oh my goodness, tell me, how did you find that out?" And invariably, it's so my other kid told me. So how did you find that out? Wow, that's and you're not going to come out and say, "Well, you're crazy," but you can that you in my view is really something that I would want to dig very deeply into to find out the origins of that. When did that start, and how did you find out, and what else has they taken, and why would they do that? And oh, I don't know why they do that. They just started. They just Dr. Schulman, a renowned capacity expert physician, says that when somebody alleges they're being stolen from, that is a prima facie indication that they have dementia, because they're trying to compensate for things that they can't find. So if they can't find it, it's not because they just they're losing their ability, their cognition a little bit. It's because someone's stealing from them.
Yeah, that's a great medical analysis that we can't forget, and those are the things that are going to get thrown back at us. I think the more common in my experience, but not necessarily in yours, Jordy, is the stealing tends to be an outlier answer. Most of the time, it's the relationship. It's the soft breakdown, and that's where I find it tougher because you have to be so careful not to get judgy about it. Right? You say, well, look, I've reached out to my son 3 times in the last year and he hasn't returned the call. Well, that's maybe different than reaching out 3 times over the last 11 years. And you start to, in your own way, you can get lazy, starting to say, okay, that's outrageous. 3 times in a year and not returning a call from your mother who's in her 80s, that's outrageous. In your own mind, and you start imparting your own analysis. And so I really take a deep breath, and we've all done this long enough, Jordy, you and I, to realize that, behavior that's driving it can be absolutely sincere, but it's individual based. And so what I just try to do is I keep coming back to, okay, let's just hear a little bit more about that. Let me work through that. Let me understand that. And I'm not afraid to early on the discussion say, there's a kind of a bias and an assumption that you're going to treat your children equally. So we just need to dive into this, and I need to be able to understand it because I want this will to stand up, and I don't want someone later to say, you forgot that that's the bias. So I don't mind dovetailing into in plain English as best I can, the reality that, that's all well and good, but I need to know more, and maybe it's embarrassing and maybe it's not something that you want to get into deeply, but I need to know more or else this isn't going to work.
Yeah, I mean, I agree that often there isn't that stealing situation. It's a true estrangement. The proof of the event I have down there. Can it be shown that because usually there is something that's going there that occurred. And so, proof of that event, oh, who was there? What did they say? Those kinds of things. And then, of course, the timing of the estrangement. So, how long haven't you spoken? And that ties into, and I've mentioned this before, prior wills. If it's been 20 years since you've spoken to them, but the last 3 wills over the last 10 years have all included that person, what's changed? To drive this. And that's a question. Look, it's really about documenting the answers and asking the questions. I mean, we're not in a position to say this is grounds for exclusion or not. That's not our role, but it is our role, I think, to inquire and document the responses, and things like changing the relationship, changing over time, reconciliations. When was the last time you spoke? What happened? Do you see each other at Christmas and things like that?
Yeah, and I add to that too, is in my inquiry, I'll ask about direct and indirect efforts to reconcile or reach out or not. And I say indirect, I mean, if you're having an estrangement with your daughter, are you reaching out to the grandkids? Are you reaching out to the son-in-law? Are you doing anything beyond just reaching out to that single child to see just how deep the estrangement is? And that can be a real sign. I mean, kids are often used as a tool, unfortunately. So when you say we reach out to your grandchildren, and the client will say, well, they won't talk to me, that is one answer. But often I'll say, well, have you reached out to your daughter's husband? Has there been any connection there? Because that might be something that and then you get back, well, look, I even tried that. I spoke to him. I offered that I could try to heal this wound or talk to my daughter, and he said he would pass it on, and I never heard from her. That's a very powerful test of the estrangement, and one that is not as driven as by using an outreach to grandchildren.
So here are just some other questions that, when confronted with these instructions, I typically want to know about. The first one, does this person know that they're being excluded? Is this going to be a surprise to them? And what's the expected reaction? What do you say about telling parents to go talk to that kid and tell them they're being excluded? Do you have thoughts on that?
Yeah, well, look, I mean, as I say, depending on the nature of the estrangement, efforts to outreach are what will inform it. Now, a parent doesn't have to bang their head against the wall, and they may not want to reconnect. It may be that there was an estrangement as a consequence of a series of events or one event, and they've decided not to connect. So I'm not here my dad used to say, I don't wear the right collar to solve all the family problems. I am not here to solve the problem. I'm here to test what that estrangement means. And it comes back to my earlier point. One-word answers don't get you there. And too often when I cross-examine lawyers, I see people who will say, well, I asked and he said he's been estranged for 10 years, and that's the only note. And so from my perspective anyway, I'm not here to solve it, but I'm here to make sure I fully, as best I can, understand it. So I come back to my clear rationale, and I'll often use those words in my note. I've investigated it based on my inquiries. I've undertaken capacity assessment analysis that I normally do. I'm confident on the capacity, but I'm also now convinced that there's a clear rationale. As I say, I'm not here to fix it. I'm here to understand it.
Right. I do deal with the third one, which is at least having the client understand that there's a huge emotional impact, whereas they might see it just as, oh, they don't need the money. Let's say that's the rationale, right? Or they don't need it as much as their sibling or whatever. It's important, in my view, to make sure they understand that a will is not just about money. It's really the last thing that a parent says to a child, in a sense, and it's in black and white forever and in public record. So that's going to have maybe a bigger impact than some other decisions. And so in light of that, in light of the fact that the child is going to be have no one to be mad at besides their sibling who's left behind, and and draw all their anger. Like, is this what you want to do? Notwithstanding that you might have great reasons to do it, just balance it against the emotional impact.
Yeah, and I also don't. I'm not afraid to remind them of the David and Goliath problem when they say, "Well, look, he or she doesn't need the money. Um, they may have the money to make trouble." And so I remind them that that I take exactly your point, and I take it that one step further and say, just so you know, if they've got a lot of dough, they might be the first ones to hire the lawyer on an attack. So.
Right. And then there are some other, options, right? There are, for example, you could gift while you're alive more to one kid than the other. Use joint assets and things like that. Not that those are perfect solutions by any stretch. The other one is sometimes where you got a financial management issue for one kid. They can't handle money, and so the parent says, "Well, I'm going to just cut them out completely." There are alternatives, as I often point out to them. Like, we could set up a trust for that child. And yes, you're treating them differently, but you're not cutting them out completely. Like, there are other ways to protect a child without just cutting them out completely. Do you
I
have any
agree.
point about trying to get some sort of release? Let's say it's the situation where the kid's got enough money, and so they've said, "Oh, I don't want anything from you, mom. That's fine." Is there anything that you can do to document that?
Well, I think that's, yeah. I mean, that's comes back to the old thing that if you want a gift during lifetime, do it by deed of gift. It's the strongest way to do it. And if you want to protect the estate from attack before death, you have to be transparent, and you have to obtain a release in that sense. The problem comes down to is it's like independent legal advice for marriage contracts. It always comes down to disclosure. And so you say, look, you're the rich guy in the family, and you tell me you don't want any money. You want to sign something to that effect. And it's, the first answer on the challenge time is, geez, I didn't know mom had that kind of money. And geez, I wish I'd known that. I would never have signed it. So you just have to be careful about that. I don't typically get, I mean, you have more volume than I do in this. I don't see that very often.
No, neither do I. But I wanted you to just address that, because we sometimes have that raised by people.
Yeah.
It's not going to be a foolproof thing. I mean, it is helpful for sure.
Mm-hmm.
I think so just in our remaining time, let's just go through, and we may go a couple minutes over because we started a few minutes late, just to give everyone a heads up. But let's talk about what strategies do we have to protect the will? So we've talked a lot about, the questions we're going to ask in our notes. Obviously, that's fundamental. I'm going to address the second one. Maybe Ian, address the idea of having the client write a letter, or what would you recommend in that situation?
Well, look, I mean, those are those are cut both ways. I mean, from a litigation perspective, those notes can be gold, and they also can be poison to a lawsuit. And so, I think a note is better if it's done right, but it's a dangerous tool. And my first preference is that you come to a lawyer, and part of the retainer is to help protect the will, and that the lawyer is the one who's documenting the intentions. But a note can be a powerful tool, but the difficulty is of course, who made the note, well, of course it can be in the person's handwriting, but if the undue influencer is sitting right beside her and all of those sorts of things, it brings to it some real exposure.
I have a practice now where I record all of my meetings. Now with Zoom, it's sort of built in. But I always have believed that a judge hearing a testator saying they don't want this child to benefit, and here's why, in that discussion, is a powerful thing. Does it open yourself up to risk? Of course. You can't hide anything at that point. And you can also often hear things that might lead to you thinking, wow, this person, can't remember off the top of their head all their grandchildren's names and things like that. But in my view, and I'm probably one of the rare people who does this. I feel comfortable with that. So that might be, again, like Ian says, that cuts both ways and can lead to exposure, even for you as the lawyer, if you're not very careful.
Yeah, I just worry. I agree with you, and I think that's a good practice and the best practice. My concern is seeking out third-party sources by recording. That always worries me, and because when you're in a lawyer's office, a discussion is very different than when you're in a having tea with your mother and saying, hey, do you record how much you hate your other son? Like that kind of stuff is where really dangerous evidence
I'm talking
gets
about,
created.
for sure. I'm talking about me as the lawyer doing it.
Yeah, no, I agree. But I'm just saying, in terms of recording, generally now it's such a easy tool that I'm finding people say, I'll get into a lawsuit and they say, oh, well, I've had like 10 recordings with my mom about this, and I'm like, I'm not sure I really didn't. Well, now they're relevant, so I got to hear what they are, and we'll have to produce them, but they may not be the best thing for us.
The proof of understanding is just making sure, whether you're using, software or whatever else, that it's easy to show that the client understood what they were doing. When I used to use a whiteboard, I would write, nothing to John, and that was on the whiteboard. If you're using eState, they can see that John is excluded. Those kinds of things, very, helpful that this wasn't a mistake, obviously. Let's just talk about, before we get to the actual will contents, let's just talk about assessments by doctors or other people. Can you just address the old note from the family doctor?
Sure. And that's literally a brand new file came in today that's the only supporting evidence. And it's such a dangerous piece of evidence in so many respects, because typically this person went to three people, went to two of their specialists, and then finally both specialists said, look, we don't have the expertise. You need to go to your family doctor because they know you best. And the family doctor does a one-line note, which was completely useless. It seems to me that if you're at the level of needing a capacity assessment, do it right. And although it will cost some money, that note in and of itself, the one-line doctor's note, isn't typically a sufficient amount of effort, because the GPs are busy, and they typically are dealing with your physical ailments, not your cognition.
And the other thing is that they don't know what the test for testamentary capacity is. They'll write something like, this person can take care of their own affairs. I mean, well, that is not the test for capacity, testamentary capacity. I think in another session we may talk more about capacity assessments, but obviously by a qualified person who knows about the test, who's for capacity, who's informed, has experience with this, and addresses their mind to this very issue, is very helpful. And there's some anecdotal evidence that if you have one of those made contemporaneously, there has never been a successful will challenge. Now, I don't know if that's true or not, but that's what I have heard. And certainly I've never seen a successful will challenge where there's a contemporaneous assessment by a competent expert. So the last thing I just want to address is, what should we be putting in our will? So let's talk first about, I'm just going to drag this over here. So in this case, we've cut out two kids. My general practice and the way eState Planner works is it looks at what you're doing. It looks at the family and sees, oh my God, well, I don't know what it says, oh my God, but it says you've excluded these people from any kind of gift, these children. And so we're going to put in this clause that says, I have considered this and I have deliberately excluded them from sharing in my estate. So I prefer to put something in there about that. I don't typically put in because of this, that, and the other. Um, so this is sort of what I would typically include. Ian, do you want to address whether we should be putting the reasons for exclusion in the document itself, in the will?
Yeah, sure. And it may just be my connection here, but I'm not seeing any screen sharing, Jordy. But
Oh,
uh, um,
okay. Well,
but
hang on 1 second. Let me stop
that
sharing and then start sharing again.
while we're talking about your sharing, it may be just my my thing. Um,
Can you see
and if,
now?
yeah, I am. So I just worry that people weren't seeing the
Sure.
slides, and it just. But we those are available, obviously. Just to pick up on that point, I am with you 100%. I find that putting too much in there, it's the lawyer's job. Oh, good. People are saying they saw the slides. It's the lawyer's job to document, and it ends up as I call it gossip. It's will gossip. All right. The fact is that clause says it all. It identifies the issue, and the note taking and the documentation has to fill that in. I find that, I mean, it's a public record document. Even the secondary wills can, of course, get exposed to that. And what happens is in these situations is that we end up putting stuff in wills that are publicly scrutinized and unnecessary.
And the other technique is the idea of, and this is if you're treating kids differently, not necessarily excluding a kid. You wouldn't include a forfeiture clause or a no contest clause where you're excluding a beneficiary completely because there's no disincentive. But this is useful if you're going to give a child something less than their siblings, for example, and you want to say to them, well, if you challenge this, well, I'm taking away that gift, even though it's less than you were getting, you're going to get nothing if you're unsuccessful. And so this is our no contest forfeiture clause that, again, eState looks at, but would only include it if you're treating your kids differently as opposed to excluding them completely. And these are all automatically put in based on the circumstances. And then you can decide whether that's something that the client, with the client, as to whether they want to include it. And we could do a whole session on forfeiture clauses, but I just wanted to address that these are concepts that are considered by eState Planner and included in the documents automatically based on the circumstances. So, and I like to keep it to exactly half an hour. So any concluding remarks on this, Ian, about these kinds of situations?
No, I think we've covered it. I keep coming back to my definition of a documented, clear rationale for doing it. The only other thing I will do is I can say is that don't forget, and I tell my clients this from time to time, is that it can affect the choice of planning, is that the kids can turn this all around. I have a contract that I will give the kids if I get a situation where there's been unequal treatment, where the kids all sign and say, I know dad's going to do this to me or to two of our kids, my siblings. Whatever happens, I agree now. We're always going to split it equally, and it flips it around on the testator. So again, it comes back to how important is the protecting the will? How important is it going to be? Well, if you draft gift overs, you put in trusts, you put in spousal trusts, all of that. Those are going to protect from those kind of contracts.
Great. Well, thank you, Ian, very much for our first high risk instructions webinar, and we're going to have other ones down the road. And we hope to see all of you again next week. And thanks again for joining us. And feel free to reach out to us with any suggestions or questions. Thanks, Ian. Thanks, everyone.
Great.
Have a good
Thanks, everyone.
afternoon.